But our current focus is on the other danger, radical policy carried out by an unaccountable judiciary. Let's turn now to the interview question on Part B of Point 2 of a Minnesota Republican state legislator's contract with voters. Part B will be displayed on screen as it's read.
Let's take a look at Point 2, and this is on the relationship between the legislature and the judiciary. The legislature, with 201 members from all around the state and a wide variety of backgrounds, is the branch of a Republican form of government responsible and best suited for lawmaking, policy, and oversight. Unless a claimed right is either explicitly provided for in the federal or state constitution or has been established by long-standing and reaffirmed precedent, the court should defer to the legislature for resolving controversies over rights. What do you see as the role between the two branches there?
And I'm trying to read words into your question. If that speaks to the judicial activism, it does speak to that. I strongly feel that the citizens of the state or of this country through their legislature should be the dominant body, and that we should not have appointed persons legislating from the bench. If in fact this does speak to the judicial activism, which some of us claim we've seen. Now, I understand that when I say that the bench, the judges, have been placing their activism, their philosophy, rather than just interpreting the law, while I will claim that in certain cases, there are a whole host of other Minnesotans or citizens that feel differently.
Yep.
So I certainly would tell you that judicial activism, from my perception, has been too great, and that they have the bench has gone beyond interpreting the law to try to make the law, which is a right given only to this legislature through the citizens.
This is the view stated in our Minnesota Constitution right at the front in Section 1 of the Bill of Rights. I emphasize the phrase, "in whom all political power is inherent." As I score this, I think it's fair to say Speaker Swigum agrees with Part B that in resolving controversies over rights, the courts should defer to the legislature. As I see it, the so-called marriage amendment, putting a definition of marriage in the Minnesota Constitution, is an example of a reaction to concern about the danger of judicial activism. Minnesota already has a law defining marriage as the union of a man and a woman. Advocates of the marriage amendment want this put in the Minnesota Constitution to ensure that no court can rule Minnesota's current law is unconstitutional. To me, this is the wrong approach because it doesn't get at the more general issue of judicial activism. To get at the real underlying issue, I have developed my own proposed amendment, and as we'll see in a minute, Speaker Swigum said he could support my approach. First, we'll take a look at the amendment in detail, then we'll watch the interview discussion of it. Whenever a state court holds any non-criminal Minnesota law violates the state constitution, the court's order shall be stayed for 90 days. This sentence simply provides for an automatic 90-day delay in enforcing any state court ruling that a non-criminal Minnesota law is unconstitutional. This 90-day period is designed to allow news reporting and to allow people to decide for themselves if they think this ruling is a case of judicial activism. Notice that if criminal law is involved, this amendment doesn't apply. Instead, the benefit of the doubt is given to the court. Of course, the Constitution can always be amended later according to the regular amendment process. Here's the next section. If during this 90-day period the Secretary of State's office receives a petition for amendment review that is signed by 25% of the members of either house of the state legislature, the court's order shall remain stayed until the completion of A, one full legislative session commencing after the date of the court's order, and B, one subsequent general election. This section provides that if 25% of the members of either house of the legislature think a court is engaging in judicial activism, they can petition for a review. Their petition extends the delay before the court's order can take effect. Now the legislature has a full session followed by an election to put an amendment up to a vote of the citizens, to let the citizens decide the issue for themselves. Here's the next section. During this time, in addition to the legislative process for amending the Constitution, an amendment shall also be placed on the ballot if a petition for the amendment signed by 50,000 Minnesota voters is received by the Secretary of State's office no later than the first Monday after the first day of October prior to the general election. This section allows citizens to bypass the legislature and put an amendment to a vote directly. However, this can only happen if at least 25% of one legislative body has already petitioned for an amendment review. This prevents one house of the legislature from being able to block a vote by the citizens. Here's the next section. If any such amendment is approved, the court's order shall be vacated and the case shall be heard again, with the approved amendment to be taken as the most relevant rule of construction for the case. This section establishes the ability of the citizens of Minnesota to, in effect, review the rulings of our courts. If Minnesota's citizens think a court has been activist and has gone beyond what a majority of citizens think is a right, the citizens can clarify our Constitution to make it clear what Minnesotans agree is or is not a constitutional right. The courts are required to then rehear the case and to apply the new amendment to resolve the constitutional issue. Here's the last section. The legislature shall implement this amendment through appropriate legislation and may by law provide a process for consolidating multiple amendments if they are substantially consistent in effect. This section requires the legislature to implement the amendment and gives the legislature power to both fill in the details and to make modifications to the procedures when needed. As you can see, this is a little complicated, but the main idea is clear. This is a way to build in a review process by the citizens of Minnesota to guard against the danger of judicial activism in a general way. Now we'll go to the interview discussion. I outlined the process quickly to Speaker Swigum, and we didn't consider the citizen petition option. Here we go. One is on this alternative amendment, and I want to run this by you briefly. This is something I met with Senator Neville on. And here's the process that's outlined. I'll give you a copy of it. Essentially, the idea would be that whenever a Minnesota state court holds a state law unconstitutional, that there be an automatic stay of 90 days. And during that time, either house of the legislature could petition, 25% of the members could request an amendment review. And if that petition is received, then the stay would hold for one legislative session and one general election. And if an amendment emerged and got passed during that time, then the court would have to simply rehear the case based on the new amendment. So the idea is, instead of trying to guess what a potentially activist court might do, why not simply have a review built into the process by the citizens?
I like the thought. I like the process that you're outlining here.
You think there might be some merit to this?
I think there might be some merit to this. I am obviously, and this refers, it could be all rulings within the courts and all state laws and all constitutions, all parts of the Constitution of Minnesota. This specifically refers to the Protect Marriage and Marriage Amendment.
Well, no, this one, you see, this would cover the marriage issue. On the one hand, you wouldn't have to do anything in advance. If a quote-unquote activist court held that it was a constitutional right of the state constitution, probably an amendment would emerge. But if that doesn't happen, then nothing has to be done. But in addition, of course,
because then it would just be state law, and people would be would feel satisfied that the state law we have would not be overturned, such as in Massachusetts.
Yep.
And we also see now in other states, significant other states, including our neighboring states to the south here in Iowa, their state law is being challenged right now. So I think this is certainly a fallback position, which is reasonable to look at. I think that it would give Minnesotans a little bit more protection against, quote, judges which would rule contrary to the law or contrary to our interpretation of the law. I wouldn't have any problem with doing this. I will also tell you I am a strong supporter of the marriage amendment, and I do feel that marriage should be between one man and one woman. This doesn't say it's not. It doesn't say it is. It just says that if the courts were to overturn the state law, then there'd be a 90-day stay for the legislature to address it in a proactive way at that time.
That's right. I also asked Speaker Swigum if he thought this would help shield the judiciary from politics. It seems to be a danger right now.
Yeah, I think it probably would. I think it probably would. I think it would it'd make the judiciary a little more cautious, I would guess, wouldn't it?
But also, of course, on the one hand, the judiciary could be a little bit less worried because the voters would have a final say on it. But hopefully this might avoid politicizing the judiciary.